Hello, everybody. Can you all hear me? Someone give me a shout out in the chat box. Am I coming through? Can you hear me? Awesome. Great. So this is fun and it's new. Welcome to my first pop-up webinar. So this should require very low bandwidth. I am going to share some insights and thoughts, hopefully on the practical side for a change. But I really also want to hear from you folks in terms of, what's on your mind as the big questions and concerns and your thoughts on how you could come in line with the new policy update on redeployment, because that's going to inform my advocacy before USCIS through various groups and also on my own, and also in how I communicate with various other stakeholders, including clients and others, about this new policy and how we can comply with it. So I'm going to share with you my very quick PowerPoint, and then hopefully we can open up to have some conversation thereafter. Here we go. Okay, so this is us. Disclaimer, I am going to be talking about some practical concepts. So I want to make sure that we're clear, as I'm sure we are, that this isn't legal advice and that this is informational only. And we're only going to really touch on immigration. I am going to talk about some other practical tips and recommendations that touch on other areas, but that's certainly not legal advice, because that stuff is outside my zone of competence for sure. So look at the central question for all of our collective brainstorming and thinking about is, under the redeployment policy update of July 24th, 2020, which has retroactive application on pending EB-5 cases, what if further deployment already took place outside the original regional center geography, and there are pending EB-5 petitions, Form I-526 and 829 petitions? What are we supposed to do? That's the question that this is about. So what is the impact on pending EB-5 petition cases? The 526 impacts. These are a little more concerning, I should say a lot more concerning than in the 829 context, mainly because of the cloud of material change policy and how that works. If you're not yet in conditional permanent residency, material change is like a cloud over the investor's case. Once you clear conditional permanent residency, once you're admitted in conditional permanent residency, then even regional center termination is not as prejudicial as long as there's been job creation and the investors kept their capital in the new commercial enterprise. So 526 impacts. USCIS may deny the pending 526 because the policy is effective now expressly on pending cases. USCIS may also revoke approved I-526s if the geography change is deemed a material change. I think there is a question on this as to the interplay between the new policy that's effective now and material change. For further discussion on that, see my earlier webinar. But the point is that USCIS may use deployment outside the original center geography to revoke 526 petitions that have been approved, unless the geographic amendment was approved before the redeployment. And that is under the terms of the question and answer that the service came out with. It's saying that if the regional center sought a geographic amendment and that geographic amendment was approved before the redeployment took place, then those petitions are okay. I'm not sure that this is the occasion to go into how weird that really is, because the 526 petition was approved when filed. So the fact that the geographic amendment has changed after filing really shouldn't have any impact on that. And this odd wrinkle that carves out when it would be okay if the redeployment took place before the geographic amendment was approved, it's okay. It just smacks of being very, very much made up, very much outside the existing legal framework of approvable when filed. That's the rule. The case has to be approvable when filed. Let me open up the chat box in case you guys have questions while I go. So give me a moment to do that. Awesome. Okay, 829 impacts. Okay, so it's less clear. It's not clear, I should say, but to my reading, it seems to be more favorable because of the operation of the material change policy. If you're admitted in conditional permanent residency, project derailments, business plan departures, not as worrying as a general matter. So based on that principle, if redeployment took place after admission in conditional permanent residency, logic and policy would hold that the 829 should not be adversely affected, again, as long as there's job creation and sustainment of investment. There is a tiny bit of unclarity here as well, tiny bit in the relative sense, something that is concerning to me as an advocacy matter. And again, this is covered in more depth in my earlier webinar, but there is language that still remains in Chapter 5 of the policy manual that the update did not edit. And that language says that the 829 investment for 829 approvability has to be sustained at risk. So what does that mean? Does that mean that all of your redeployment policy requirements still have to be met and sustained through the duration of the conditional permanent residency status, or even possibly through sustainment period, which is after admission in conditional permanent residency? Sustainment period is the 2-year period of conditional residency. So this is language that I'm focused on as an advocacy matter that I think USCIS should lift right out. It was put in there with the June 2017 redeployment policy, didn't have any place in there to begin with, and it has less of a place now with the policy redeployment update. So that's what gives me pause. But in general, I think it's pretty fair to say your conditional permanent residency status, we're going to worry less about you than we would if your 526 petition is still pending. So some practical thoughts for investors and investor representatives. You're going to want to communicate with the regional center or the commercial enterprise manager, particularly if you're sure or if you're fairly certain that this new redeployment policy update affects you. And of course, we're talking about the fact that the new policy update says that if the redeployment took place outside the original regional center approved geography, that is no good, it's not compliant, and this policy rule affects pending EB-5 petitions. So if you know that your investor client's regional center redeployed outside the original regional center geography, I think you are going to want to communicate out to the regional center or the NCE manager about their thoughts on this new policy and how it affects your client investor situation. So I would start with what are your thoughts? This is sort of a polite way of making sure that they are aware. This is a very serious development. Everyone in the industry is talking about it. IIUSA and American Immigration Lawyers Association jointly submitted a 30+ page comment to it. Lots of other stakeholders hopefully submitted comments on this. We're all talking about it. But just in case, you do want to make sure that your client's regional center and NCE managers are aware of this, and you want to know what they're thinking about it. So I think it's fair to ask what you're thinking about it. And more to the point, if your investor client is affected, you're going to want to ask some questions about what is your plan. And I would say it is fair to expect the regional center and the new commercial enterprise managers to be thinking about it, because all of this is incredibly new. It's we've all been whipsawed by this. This is not what we were expecting by way of clarification. We were expecting confirmation of the prior written guidance, which is that there should be no restriction on geography. So you're going to want to give the project managers some time to absorb all of this, the impacts on this, and the transactions that have already been undertaken. Also, we're not sure whether or not this policy is going to stick around. I submit to you, it shouldn't, because it was promulgated without due process. And so based on that reason alone, even without going to the substance, USCIS should rescind this policy. So that could, and again, should happen, in my opinion. Doesn't mean it will, but there is that major procedural defect that casts the legitimacy of this policy in serious doubt. So USCIS may rescind this policy or choose to promulgate this policy with prospective effect only, which would be the next best thing. So a full reversal of transactions, a full unwinding, even if that's possible, which in many cases it's not, might not be the most prudent, particularly if the alternatives aren't great. Alternatives meaning redeployments within the original regional center geography. I think it's fair to ask about time frame. Okay, so if you don't have a concrete plan yet, understandable, what is your working time frame generally? I think that's a fair question. Also, you might ask them, what are your thoughts on interfiling my client's I-526 petition? Now, I think ultimately the prosecution of your client's petition and your investor's immigration process is on you to make the decisions based on your best judgment for your client. But I think that conversation between investors and investor counsel and the project regional center NCE managers can be productive and collaborative. So I think it would be fair for you to ask for the regional center's thoughts on that. So regional centers and NCE managers, I think for you, it's about, at this point, developing a communication strategy and a response and compliance strategy. Communication strategy. Now, this is based on my experience representing regional centers, NCEs, and NCE managers over time when things happen that are unexpected. Responding to investors and representatives, I think, is key. And this is not all NCE managers adopt this approach. But I think it's very, very important to respond when you get a question from the investors or investor representatives. You want to respond to that. Beyond that, an affirmative message, even getting ahead and coming up with and crafting and disseminating an affirmative message about this policy. Yep, we are aware of it, and we are absorbing this, we're analyzing it, we are assessing its impact on our redeployment transactions, and we will communicate back to you when we have something more to report. But it gives your investors assurance that you're on top of it. Updates. So as this is an evolving development for everybody to absorb. And I think that that's an important element to get out in your communications. And this includes investors and investor counsel. If your investor client is upset or concerned, that's all understandable. But expecting a complete actionable answer at this moment in time is not reasonable. It's all too new. We're all absorbing the impact. So communication, but also the sense that we're all kind of watching this and monitoring and absorbing, but we are actively engaged. I think that's the message. Action and proposed action. When you get there, when you have something positive or affirmative to report by way of action you are taking or about to take, maybe action that is up for a vote among the members or limited partners, I think that's probably a good thing to communicate out as well. Now, these communications obligations may also be governed by your new commercial enterprise agreement, the operating agreement or the LPA. So certainly consult that and the counsel who helped you draft that. And other principles that are at play here as well relate to securities disclosures, fiduciary, and other applicable principles that are outside immigration. Response and compliance strategy. In terms of what you are going to be internally thinking about as project NCE managers and regional centers affected by this policy, is you are evaluating your options. And in some instances, in many instances, your options are quite limited because the transactions have already been entered into. These are binding commitments that can't simply be unwound because we have a government policy that's effective on the day that it came out. So that the options afforded by the transactions already undertaken are going to drive the options that you truly have axiomatically. In some instances, the interpretation may be that you do have some options beyond none. And in those instances, I would even say that full reversal may not be the most prudent course of action for all the reasons that we've been talking about. However, given that this policy is effective now, some good faith steps toward accommodation, absolutely appropriate, in my opinion. So what are the things that, this is all after analysis of the applicability of the new policy update and options. So what are the steps that we can be taking now in consultation with advisors? What are the options within the original regional center geography? Those are concrete steps that new commercial enterprise managers can be taking now. And I strongly recommend that those actions be memorialized in some written record. I think that can only be helpful. Think about the time frame, gaming out the time frame for all of these activities, I think is important. We do now, as many of you have pointed out, we're already non-compliant because the policy is effective now. So what time frame do we have? What are we talking about? I think that is all very true, unfortunately. We do have this notion of 12 months. Now, under the policy, that 12 months is referring to the time frame, the commercially reasonable time frame for redeployment, which is the transaction from the time of repayment to the new commercial enterprise to the time of further deployment of that repaid capital. That's my reading of the redeployment transaction. So that doesn't apply to accommodation or reworking of the transactions already entered into. And that's the outside, I would say that's probably an outside time frame as well. So, but it is something for us to work within. So think about how the accommodation transactions or plans might fit well within, shall we say, that 12-month time frame. Building a record, as I said, I think is critical. And again, you want to look at your NCE agreement and your disclosure and fiduciary and responsibilities and other principles that apply here. Email comments. So my last webinar was really a campaign to get folks up to speed about the policy update and to submit comments to USCIS, because it's so harmful and egregious to have immediately effective new policy with retroactive application on pending investor petitions. And they were due before August 24th, and it's August 25th today. However, by terms of the service's published instructions for feedback on policy manual, feedback is accepted anytime. And I've cut and pasted the relevant section here that confirms that. So I would urge everyone, even though the deadline for comments has passed, to continue to provide feedback on this issue. And I think that the points to advocate for is rescission and following notice and comment procedures and prospective policy application. Short of that, prospective policy, not this retroactive application business. So now I am going to open the floor for questions and comments. So I would like to know, what are the big concerns that you all have, and what's the feedback that you're getting from your constituents, your investors? If you've been communicating with your regional center, what's the feedback that you're getting from them that you like, that you feel is wanting? I am very curious to hear that. Come on. I am not yet allowing anyone to talk, but you are welcome. Well, maybe I should. Maybe I should open up the floor. Oops, wait. I didn't mean to single somebody out here. I don't know who it is either. Disable talking. All right, never mind that. I'm not going to open the floor for speaking just yet, but maybe I will. Any questions? So what is the biggest worry that you have about this? Do you, first of all, have folks submitted comments? Show of hands. I don't know if I can see hands on this. Or respond in the chat box. Yay! Yes, we have folks who have submitted comments. I did. I think this is really important. Again, reach out to your own stakeholders, share that little snippet that I shared with you all. Feedback is open anytime. They said so. So please encourage all of your friends, stakeholders, investors to write about this, because they're all affected. If they have a pending 526, pending 829, approved 526, if they're in the visa queue, they're all affected by this. And no doubt, if USCIS does not get feedback that takes them to task on how this was rolled out, this will remain our policy, and it'll affect pending cases and approved 526s. Yay! I'm hearing that you guys are submitting comments. Awesome. Q&A. Okay, there are many clients asking about updates on redeployment policies, although not impacted. They rightfully want to know if we have a plan. Absolutely. I mean, yeah, this is no good. This isn't the way we should be regulated, but this is also an opportunity for us to reach out to our stakeholders to let them know that we're very engaged in our industry. We're very aware of government actions that affect our state, our clients, our investors. And we're taking this very seriously. And these are the steps that we're taking. Absolutely. I think that reaching out to your stakeholders, even those that are not directly affected by this in an adverse way, is awesome. You're only going to win greater confidence this way. Another question. Currently, I-526 petitions may not be filed whilst an expansion I-924 is pending. How will this affect redeployment? That's correct. So until your 924 for geographic expansion is approved, you can't file the 526 petition for a project in the expanded geography. So those investors are not affected by the redeployment policy because the retroactive impact of this doesn't affect them adversely. Their 526 petition is only going to be filed once your geographic amendment is approved. So I guess if the question is, okay, I have investors whose repaid capital was deployed outside the original regional center geography, and the expansion was still pending, what's going to happen? Unfortunately, you're out of luck because the policy update says your 924 geographic expansion has to have been approved before the redeployment took place. The 924 expansion amendment has to have been approved before the redeployment took place. If this affects you, you absolutely need to reach out to USCIS about this. You're in the same boat as folks who redeployed outside the regional center geography and under the terms of the prior written policy. You were not told you couldn't do that. All right. Any other questions? Okay, we are at the top of the half hour, and I really, really did want this to be a light exchange and dialogue, and I hope that you found that to be true. And I hopefully will have more of these. They're easy to do, and they're fun. So thank you for participating. Have a great evening and rest of your afternoon, and we'll talk soon.